Welcome to Beyond the Law.
Beyond Law Group's podcast that brings you unfiltered conversations
with our lawyers, clients and friends.
We'll be having frank discussions about our experiences in the legal sector,
sharing our thoughts on current topics from a legal and a personal standpoint,
as well as offering our top tips for those pursuing a career in law.
Beyond the Law.
Beyond the Law.
Beyond the Law.
Hello and welcome to a Beyond the Law podcast. My name is Jason Stanley. I am a partner and solicitor at McAlister Family Law, and I specialise in all things property, unmarried couples and cohabitation. And I'm delighted today to welcome our guest speaker, Cordelia Grassby, Head of Home Property Law. Welcome. I introduce you as Cordelia Grassby. You are probably someone with the poshest name I know on earth. Home Property Law is a new dynamic conveyancing enterprise that you head up. Tell us a little bit about it.
So we are making a change in the conveyancing marketplace. We are doing something very different. We are offering a very quality service to our clients, whether they're high net worth individuals or first-time buyers. We're here to reflect our service to the client's needs to ultimately ensure that we achieve what they're looking to do in the timescales that they're aiming towards.
Yeah, absolutely. And as a specialist in the sort of unmarried couple cohort, there is a rise in my industry of people forging relationships and not getting married and buying houses together. And I wonder if you've sort of seen that trend.
Yes.
Yeah.
Buying a property is an expensive acquisition. It's not just the purchase of the property. There's removal fees. There are sometimes fees paid to financial advisors. So when we start discussing a potential structure as to how that purchase is to be held, and we discuss there may be additional fees to set out that in writing, people ultimately don't want to have the expense, but in future life it can have a lot of impact, as I'm sure we'll touch on now.
Sure.
But it is something that really should be prioritised. I've had my own personal friends that have purchased with ex-partners. I've said to them to the nth degree, this is really something you need to do, not just to protect their investment, but to set out a fair position for them both. And unfortunately, that has come back to bite them. And it's always the case. I really wish I'd listened to you. But there's only so much we can do. And as long as we make sure people are fully aware of what they're getting into and ultimately what it may lead to, then
it's money well spent, isn't it?
Yes, exactly.
Just for the listeners, we have this concept of legal title. Mm-hmm. So you're on the land registry, but also beneficial title. And there is a complete difference. And perhaps just simplify, if you were talking to a layperson, what that is.
So a legal title is, as you've said, you're registered at the land registry. The beneficial title can be held in a number of different ways. You can be joint tenants, which means there is no division in ownership. You both own the property jointly. If one of you were to pass away, the property would automatically pass to the remaining owner. If you hold the property as tenants in common, there is a division in your beneficial ownership. That can still be 50-50 if you've purchased separately. That may be an example for people buying property in later life, for example. They have separate children. They still want to own that property jointly. They put in the same amount of money, but ultimately they want that share in the property protected so that it passes to the beneficiaries of their estate if they were to pass.
Because if I try and help people doing cohabitation agreements or advice to unmarried people who may have some wealth, or not as the case may be, before purchasing, I'm also the guy at the end of the thin end of the wedge, advising people who have a dispute about how they hold property. And the first thing I do in that scenario is I get your conveyancing file and I look for this document called a TR1 form, a transfer deed. Mm-hmm. And that's crucial to me because what it is essentially, and I'll let you as the expert provide some more detail, is it's a timestamp of what you absolutely intended to get when you purchased. Mm-hmm. What is your clear intention as a couple? And so where does that fit into the sort of process of conveyancing?
So a TR1 form is the document that's submitted to land registry when a property is purchased.
So the purchasers will have to complete it, won't they?
The purchasers draft it, purchase solicitors draft it. It's approved by the seller solicitor. What the seller solicitor is looking at is just the surface level details.
Okay.
Ultimately, they're not concerned about how the property is going to be held post-completion. And that's why it's drafted by the purchasers solicitors. It's important to start the conversation as to how that property is going to be held very early on in the process. More often than not, it's an ongoing conversation. It's not something that people have an express agreement at the very outset.
Right.
The transfer is prepared. We would insert how that property is going to be held, whether it's joint tenants or tenants in common. And the tenants in common has two options. It's either tenants in common in equal shares or it's tenants in common in unequal shares. We can insert additional wording to confirm the percentage that the property will be held. However, the Land Registry will register the transfer. They will keep a copy of the transfer. If the property is held as tenants in common, there is no differentiation on the title as to whether that is in equal shares, in unequal shares. It is simply what's called a sole proprietor restriction, which means the property cannot be sold by one party independently.
Yes,
exactly.
That's right.
Now, the concern around protecting differing interests only with a transfer is that, to use an example, if you and I bought a property together, we'd had previous marriages, we put in differing amounts. It may be that during the conveyancing process, your conveyancer or our conveyancer advised us, if you're having differing shares, we should look to protect that. We may have decided actually we didn't want to expend the additional legal costs to have a full agreement drawn up. So we simply had those shares detailed in the transfer.
Okay.
Now, if 20 years passed, you passed away, your executors were appointed, we'd been together for a very long time, it may have been one of the children, for example, they may not have been aware that actually we protected those unequal shares in the transfer. In order for the property to be sold, you would appoint the executor, and if they weren't aware of those differing levels of interest, I would sign on my behalf, your executor would sign on your behalf, and I could indicate actually we're entitled to 50% each, and on we go. And the provision within the transfer wouldn't ever be known unless there were additional documentation to support the fact that there's that differing level of interest.
And that's the problem, isn't it? The TR1 form is clear evidence at the time, but that's not real life, as you say. Things could change and things could happen. And unfortunately, for those who are unmarried, they do not have the same protection as a married couple. So things like fairness, need, sharing, all those wonderful things do not apply if you are unmarried and you're buying a property. So it's absolutely crucial at the outset to listen to somebody like you who's an expert. But what happens if you get just a couple say we want to buy a house together? What might be some sort of indicators of red flags where you may get, do they need some advice here? Because obviously they're unmarried, they have different surnames. What other circumstances might you be going, I might want to stay somewhere else, to think about that carefully?
So unless a client comes to me and they are purchasing jointly, they are putting in exactly the same to the deposit, the fees, the stamp duty. Ultimately, their intention is long-term that they will contribute jointly in equal proportions. In those circumstances, tenants in common, joint tenants, it's absolutely appropriate that you proceed without any further sort of information to protect their interest. If we have, and this is quite common, somebody that's previously owned a property, they're now selling their flat, for example, buying a house with their partner. The sale proceeds are coming from that sale. Another example, if somebody is getting a gifted deposit from parents, they're coming to the table with a significantly chunkier part of the deposit than their co-purchaser. As soon as we see that, we're raising the question, have you considered protecting your differing interests in this property? And it's not just to protect the person that has the high level of deposit, it's to protect both of you, because ultimately it may be, whilst they are contributing a higher amount at this stage, that's going to be adjusted in the future so that you would pay more towards the mortgage, for example.
Well, we did a case, didn't we, where we had a wealthy individual who wanted to buy in joint names, but he front-loaded all the acquisition costs. And his partner, over time, I think she was tracking a little bit behind in his career, was going to make huge capital payments either off the mortgage or contribute to the property. And you and I worked together in such a way where we could be flexible with the scenario. There was a moving target, essentially, the shifting sands, where she essentially acquired or aimed to acquire that 50% interest. So you're not stuck with rigidity, are you? You can be quite flexible.
Absolutely.
And let sort of how your life pans out mould how you hold your legal title.
Yeah, absolutely. The position that you set in stone at the point of purchase isn't something that binds you throughout the entirety of your ownership. It can be adjusted, amended at any point in the future, provided both parties are in agreement. It's something that has to be considered as the journey of your home ownership goes along. If, for example, you purchase the property jointly, but the long-term intention is that in a year or two, once you've made further savings, perhaps somebody is anticipating a large bonus, you're going to extend the property. They're going to invest that bonus into the extension and ultimately then have a larger contribution towards that property as a whole. Ultimately, what we're discussing is a declaration of trust,
yes,
which is a document that sits outside of the transfer and just gives a lot more background and detail around how the property is going to be held.
Well, I'm finding a lot these days that in maybe a blended family where one of the co-owners' parents or family are advancing some money towards the acquisition, so you've got a third-party contribution, and I suspect the lender may want them to sign a waiver saying that's a gift, not a loan.
Yeah.
And all of a sudden, if there's a separation 5 years later, that gift is now a loan, and the evidence is against them. Do you find that lenders will pretty much insist on that?
Yes.
Right, that's interesting.
Yeah.
So woe betide anybody just offering that kind of money without these considerations.
Yeah, absolutely. It's got to be very carefully considered. If it isn't a gift, you shouldn't be advising it's a gift because, as you say, you can't indicate and confirm in writing at the point of acquisition it's a gift. The relationship breaks down and suddenly it's transformed into the basis that it was always going to be repaid. If that's the case, it needs to be made clear at the outset so that gift can be protected.
Yes.
Whenever we know that there is somebody contributing, we always ask them very clear questions. Is this a clear gift? Are you expecting an interest in the property in return of the gift? Will you reside in the property? They are very clear questions with yes or no answers.
Yes. There
is no room for any potential adjustment of those responses in the future.
Are you seeing a scenario where, say, a retired couple sell their home, advance their net proceeds of sale towards an acquisition and then actually cohabit with the couple, shall we say? And again, I'm just finding a few of these contentious points that I'm being instructed on becoming a little bit more prevalent.
Yes.
I'll be honest.
Yeah, it's not that common, but we do see it every now and again.
Okay.
And ultimately, it's something that the lender would have to consider as well,
Yes.
because if somebody is gifting monies and they're going to reside in the property and actually they are expecting an interest in that property because they've contributed towards the purchase, all parties need to be clear in what the circumstances are at that point so that everybody's interest can be protected. Because long term, sometimes people don't give consideration to the wider issues and how that may impact them in the future. And as we touched on, yes, it's an additional outlay at the point that you are purchasing the property, but litigation fees, when things ultimately don't go to plan, will far outweigh the cost of ensuring you have a clear, concise agreement that sets out everybody's perspective.
And I think while you're going through the process of instructing lawyers, you may just do it properly at the beginning, and then you're sort of future-proofing as best you can.
Yeah.
Well, I am grateful for you giving up your busy schedule. I know that I can't click on LinkedIn these days without seeing yours or your juniors' faces for client endorsements. It sounds like it's going absolutely swimmingly. And I have to say this while we're being filmed, that we're entering the Wilmslow Running Festival next year. And I think you run nearly a sub 45-minute 10K, which fills me with dread.
No, a minute off.
Well, yeah.
Aiming for maybe I should aim for this.
Yeah, I better start training. Well, again, thank you for giving up your time and instructing and advising and educating the public out there, particularly if you're in an unmarried scenario.
Thank you for listening to this episode of Beyond the Law. You can find other episodes wherever you download your podcasts.
Thank you for listening to this episode of Beyond the Law.
To keep up to date with all things Beyond, follow us on our socials at Beyond Law Group.
You can tune in to our next episode wherever you find your podcasts.